Three, two, one. Good evening, taxpayers. So finally, justice prevailed from the Supreme Court in the matter of Mohit Minerals. Today, our Hyderabad partner, Mr. Venkat Prasad, and me are jointly recording this short video for the benefit of all. So, over to Mr. Venkat.
Yeah. Hello, everyone. In this video, we would like to explain the background of the decision and the actual decision and way forward based on the decision. First, we'll cover the first part, the background in which this decision has come. So the legal and factual and legal background is this, which is try to put it in the chat form. The issue is related to the ocean freight, where the transportation transaction is there in the case of import. So popularly, there are two modes in which that the import takes place. Import contracts will take place between the foreign supplier and the Indian importer. That would be, one is on the FOB basis, another is on the CIF basis. FOB is in a short form of free on board, which means that the foreign exporter or foreign supplier will deliver the goods at foreign port, and from the foreign port to Indian port, it is the Indian importer who has to engage the transporter and who has to transport from foreign port to Indian place or Indian port. Whereas in case of CIF basis, it is where the foreign supplier only will do the transportation. He will deliver the goods at Indian port to the Indian customer. So this is the difference between first and second mode. The first method of contract, where the Indian importer engages the ship transporter. In case of second mode of contract, it is the foreign supplier who engages the transporters. This is where the difference between first and second mode. So as far as first mode, in either of the case, either the actual transporter either from India or from outside India, government is going to get its revenue, and the Indian importer is going to get credit if at all he is doing a taxable business. Otherwise, it will become a cost to him. But government is continuing to get its revenue. There is no much impact as far as the tax impact to the government or the taxpayer. So as far as this is their dispute is in this second model, that is where the import is made on the CIF basis. In the CIF basis, what will happen is, because the transporter will be engaged by the foreign supplier who is from who is not do not register in India. So if we engage a Indian shipper or Indian transporter, so it will become he has to charge, Indian shipper has to charge a GST on it at 5%, because it will not become export of services, because it is there, they have supplies in India. So thereby, whatever the GST charged by the Indian shipper will become a cost to the foreign supplier, foreign exporter. So thereby, there is a deviation in shipping business, because Indian shippers are deprived of this business, because that entire 5% is becoming a cost to the foreign supplier. So they are it is becoming uncompetitive, because if the foreign shipper engages the foreign supplier, foreign shipping supplier, so they don't get the GST impact. Thereby, they are becoming uncompetitive with the foreign shipper in case of CIF contracts, in the particularly in the context of GST liability. And this issue was also there in prior to GST also. So to avoid this disparity, what government has done, either service tax in 2017 or in GST from the beginning of GST, what they have told is, so to avoid this disparity, what government has told, so in any way, if foreign supplier engages the Indian shipper is anyway going to charge GST, and that will become a that will government gets its revenue, and also supplier is also will become a cost to him. Whereas in second case, because they can't go to the foreign shipper and ask the tax to be paid in India, what they have done is they have made Indian importer to make liable for the GST on this freight component. And they are told that Indian importer, though he is not neither the supplier of the transportation nor the actual recipient of the transportation, they made liable for the GST under reverse charge. And this is what they made it in notification number 10 of 2017, and the rate was 5%. Of course, that there is some problem in the arriving valuation also. So to that, government answered that they say they come with a deeming fiction of 10% of CIF value would be the taxable value, and that GST has to be paid. So this is where the actual challenge was made by the some category of taxpayers before the Gujarat High Court. So in case of Mohit Minerals judgment, so come down, Bhavish. Yeah, okay, fine. So Gujarat High Court, in when they heard Gujarat High Court heard the challenge and has admitted the challenge, and they heard both the sides of the department, and they have given a very detailed judgment covering various aspects of the GST introduction, how GST was introduced, what are the constitutional changes that were made, and how GST law was enacted, and how definitions, various definitions were enacted in GST. After all this provisions, analysis of the provisions, Gujarat High Court has come to a conclusion saying that the recipient, the Indian importer cannot be a recipient of the transportation in case of fourth scenario, because he is neither the supplier, is not the actual contracting party to the transportation arrangement between the foreign supplier of the goods and the foreign transporter. So thereby they have struck down that notification, and they are told it is ultra vires the IGST Act, and it is held to be unconstitutional. And while arriving this conclusion, they have given various reasons for this conclusion. Most importantly, they have analyzed the definition of recipient under section 2, where they have told that recipient definition has 3 parts, and the first part is relevant because there is a consideration is paid by the in the foreign supplier to the foreign transporter, thereby, whereas because that recipient would be the person who pays a consideration, they are told that the Indian importer is not paying the consideration in this transaction of transportation, thereby he cannot be a recipient. Once the Indian importer is not a recipient, then the reverse charge liability cannot be fastened under the section 5 subsection 3, because section 5 subsection 3 gives only power to put it under reverse charge only on the recipient, not on any other person. So thereby they are told that the Indian importer not being a recipient, the entire the notification which dealings the recipient supplier and says somebody else on the premise that he is ultimate beneficiary, so that cannot be valid, because that section is not authorizing to go beyond the supplier and recipient and tax somebody else in the transaction. So that is what the precisely that Gujarat High Court has told. And while saying so, they also held that if the person is paying tax is not a recipient of the transaction, if you look at the time of supply provisions, player supply provisions, and also the valuation provisions, recipient cannot if there is no provisions, sufficient provisions were made if person is not a recipient of service transaction. So all those provisions are also fails. Thereby, on all these reasons, the Gujarat High Court told that levy fails and the reverse charge is not liable. This is one reason what was given by the Gujarat High Court. The another important reason also is that they told when they import the goods, the actual importer, Indian importer, pays custom duty, basic custom duty, and also the IGST on the total value, including this transportation from foreign port to Indian port, because that as per the customs valuation rules, which are made applicable for GST also, they clearly told that transportation from foreign port to Indian port clearance place. So this has to be part of taxable value under customs. Thereby, there be already IGST has been paid at the time of import, and there is again asking the same importer on the same transaction of import, just vivisecting the one leg of or one part of the component of the import transaction and saying that this is different and you again have to pay GST, is leading to double taxation. And it is and also this, even if it is double taxation, that cannot be made by way of notification, and that is the notification being a delegated legislature. So they on this ground also they are told, because it's a double taxation which is not permitted under the whenever there is a double taxation, it has to be there in this specifically in the enactment, and the demufication should be there. So in absence of that demufication, the provisions of GST, just because by virtue of the notification, the double taxation cannot come, and this is also another important ground on which the Gujarat High Court held that GST under reverse charge is not there on the ocean freight in CIF contracts. So this is the outcome of Gujarat High Court decision. Of course, when agreed by this Gujarat High Court decision, the revenue department has appealed this matter to the Honorable Supreme Court. Honorable Supreme Court recently heard this matter and has given very beautiful submission, beautiful decision. So now we will see the what was argued before Honorable Supreme Court by the taxpayer side and also the government side, and what finally Supreme Court has held. So one will see point of argument one by one. First, we'll deal with the first argument by the taxpayer. Over to you, Bhavish.
Yes. So, as beautifully explained by Venkat sir, the Gujarat High Court quashed this ocean freight on CIF contract on the prime arguments that the Indian importer is not a recipient at all, and it is an extraterritorial levy. Further, there is a impact of double taxation because the entire transaction is already getting taxed along with the freight component. So these were some prime arguments along with the arguments of time of supply and all those areas. So the matter when reached to Supreme Court, the counsels from both the sides, put their maximum efforts on this particular case. And one by one, let us take up each and every argument along with the verdict of the Supreme Court. So I'll become the taxpayers' counsel. Mr. Venkat will become government's counsel and Supreme Court. So accordingly, we will proceed. So the first argument, the first and the foremost argument of the taxpayer was that Section 5.3 of IGST Act, it only allows to specify the category of services. When we see Section 5.3 reverse charge, it writes the word categories of services could be notified and not the class of services of the recipient. So this was one of the prime argument, and therefore the notification 10/17 is ultra virus. This was first argument which was placed. So Mr. Venkat, for the government counsel, how they defended this argument?
Yeah, government has defended this argument, saying that if you look at the recipient definition, it has three parts and followed by the another linking portion. What the government has argued, saying that if you see look at the recipient definition, it has the first and second part they did not stress upon. They have stressed upon this clause C, where they are told that it is the to whom the supply is made, that should be construed. One second. So they're told that the last portion of the after this portion of the clause C, that says to whom supply is made, who that person will be deemed to be a recipient. By virtue of this deeming fiction, in the CIF contract, though the Indian recipient is not the contractual party to the transportation arrangement between the foreign supplier and foreign shipper. So by virtue of this deeming fiction, and also read with the IGST section 13 on subsection 9, where it says wherever the goods are coming from outside India, the player supply would be the destination, that is in India. So there by reading together section 13 subsection 9 and the recipient definition, the department is argued, saying that the recipient has to be Indian importer, because he is only receiving the supply, he is the beneficiary of the transaction, and is also making a payment to the foreign supplier, which includes transportation, thereby and also destination being in India. So it will be constituted as a supply happened in India, and he will become a recipient. And this is the argument of department. To this, Supreme Court has also agreed with the department argument, saying that in the context of CIF transaction, we have to look at the contextual definition of the recipient, where it says that supply made to be supply no. So they have considered that last portion of the recipient definition, and they held that the Indian importer will become a recipient of this transaction. And the argument of the taxpayer was rejected, and held that Indian importer, though not being a contractual party to the transportation between the foreign supplier and foreign transporter, he'll become a recipient. And they held that he's become a recipient, and they held once he is a recipient, the next argument was also explained. Yes, Bhavish.
So the next argument, see, as put forth by Venkat sir, the revenue very smartly argued that the person is a recipient, contextually interpreting section 24.3 along with section 39 and the definition of the recipient. And the Supreme Court agreed to this argument that it is a recipient in terms of the law. and section 5(3) delegation is only clarificatory, and the law has the power to identify the recipient to any person. Means law has the power to identify an importer as the recipient. To this, the next argument put forth by the council was the importer cannot be held as a taxable person. And for a quick reference, since already everything has been explained by Venkat sir, the same argument of section 24(3) read with 39 was again put and said that section 24(3) tells every person who is required to pay reverse charge could be has to take registration, and taxable person definition says a person registered or is liable to be registered. So therefore, the importer was liable to be registered in context of 24(3), and accordingly, registration was amended, and they are a taxable person in that context. So now, again, they have said the value has to be strictly determined as per section 15(1). Mr. Venkat was discussing about the valuation. So the council of the appellants, not respondents, they said that the value to be determined in terms of section 15(1) and not by way of delegated legislation. To this, Mr. Venkat, what was the stand of the revenue?
Yeah, so the department stand, they justified this valuation of deemed valuation of 10% of CIF value being the valid valuation. To this, government has defended, and by referring to section 15, subsection 4 and subsection 5, read with rule 31, they say that wherever it cannot be determined in the normal transaction, there are rules were made, and that notification was given, so that they are trying to justify the rules and notification given under section 15, subsection 4 and subsection 5. And rule 31 also says wherever it cannot be determined by any other rules also, the policy, the framework of entire rules has to be seen, and the value accordingly has to be determined. They try to justify based on that. To this, Supreme Court also has agreed, saying that the argument that the valuation should be done only by rules, not by notification, is very unrestrictive, restrictive, and it is not correct. And they have held that the valuation that was there in the by way of notification is valid valuation, and they held that valuation is sufficiently provided for this transaction. So, which is one of the significant requirement to impose any tax on the any taxable person. So, next argument, Bhavesh.
So the next argument was the condition specified under section 211, that is import of service of the IGST Act, does not satisfy as the recipient and the place of supply are both outside India. So in this, the revenue told.
Yes. So the department argument is saying that, so import of service definition, if you look at, there are mainly three requirements. One is that the supplier should be from outside India and recipient should be in India. And third is that place of supply should be in India. So in this case, as discussed above in the first argument, when Supreme Court, one of the argument of the department, which was accepted by the Supreme Court also, that recipient, the Indian importer will become a recipient. Once he'll become a recipient, so then there is a identification of the recipient is in India. Once he's recipient in India, so import of service definition is sufficiently covered. This transaction is sufficiently covered in the import of service definition. The third requirement of place of supply being in India also is covered, because the place of supply section 13 subsection 9 says wherever goods are coming from outside India, the destination will be the considered as a place of supply. Destination being in India, so that is also met. Thereby, it is the import of service, and once it is import of service, the applicable provisions and the impact, the liability on the importer would be there. So that is was also agreed. The Supreme Court, in nutshell, Supreme Court has agreed with the government argument, saying that Indian importer will become a recipient, and he will become an importer, and he will become, it will be in the hands of, it will be an import of service in the hands of recipient. So yes, Bhavesh, next.
So basically, in the next argument also, it was argued that the person cannot be considered as recipient because he was not liable to pay the consideration. To this, what revenue said, the consideration definition includes any other person, and which was agreed by the Supreme Court. So therefore, the Indian importer, although the consideration was liable to be paid by that foreign guy, he could be deemed as recipient because consideration includes any other person. Another point which the revenue raised was any point, Venkat sir?
Yeah, go on. Only
Yeah.
point what you're told is when they were taken argument saying that consideration that, as always has to flow from the recipient. In this case, the consideration to the foreign transporter is not being paid by the Indian importer. Thereby, he cannot be recipient. To that, the Supreme Court and both the government argument which was accepted by Supreme Court is also that if you look at the consideration definition, it says not only by the actual consumer by any other person. So in this case, any other person shall be read as a foreign supplier of the goods. So thereby the consideration requirement is met. Accordingly, it will be liable. It will be constituted as supply under Section 7, and accordingly it can be taxed in India. So that is the summons, the consequence of that conclusion.
Okay. So the next argument was that transaction takes place beyond India, that is extraterritorial jurisdiction. And to this, GVK Industries case law was present, which Venkat sir will explain.
Yeah. So the argument of the both the both the sides is that the reason is that it will become because the transaction is happening between the two contracting parties. Both of them are outside India, both foreign supplier of the goods as well as the foreign transporter. So thereby it cannot have any nexus with the India, and except that goods are coming to India, there is no other nexus. If at all, because if they're taxing some transaction which is concluding and agreed outside India, so it cannot be taxed, and they have referred to the GVK Industry Supreme Court 2011 judgment, 2016 judgment, where they told that extraterritorial, sorry, yeah, to cover extraterritorial, Parliament can make a legislature to cover tax extraterritorial transaction also. But to this, the taxpayer argument was that it should be made by only in the parent legislature, that is an act or the act only, not in the delegated legislature. In this case, the delegated legislature only says other than the the foreign transaction is happening outside India, there is no act or rule which says that in case of this foreign supplier, between transaction between foreign supplier and foreign transporter will be deemed to be happened in India. There is no deemification. In absence of deemification, so they cannot tax this transaction being a extraterritorial operation. So to this government defending is that no, that existing provisions is sufficiently to cover that they can tax extraterritorials. The GVK cannot be read that only delegated, it has to be there in the Parliament. To this, which was Supreme Court also argued, agreed, saying that the place of supply provisions and import of service definition as well as recipient definition are sufficiently covers the argument of taxpayers, saying that the Parliament Act itself provides for extraterritorial operations. Thereby, so that argument was rejected and finally held that it is not extraterritorial. Even if extraterritorial, sufficient provisions were made to cover that extraterritorial operation of the GST law in this context.
So basically that interplay of 13 subsection 9 along with the definition of the recipient along with section 24(3) was contextually interpreted to consider all these things, and finally
Yes.
they deemed that importer could be very well considered as recipient under the law. So to this, there were two more game changer arguments, one from the revenue and one from the SSC. The game changer argument from the revenue side was that they told section 5(3) may not be applicable, assuming but not admitting, but section 5(4), which was introduced with effect from 1st February 2019, is certainly applicable. And when you read this, the government may, on the recommendation of the council, specify class of registered person who avail services from unregistered supplier. They can declare it under reverse charge. So now they in principle argued that our notification reference number was wrong, but the lawmaking power was always there with them. So to this, the court observed that.
Yeah, court has observed. See, yeah, Supreme Court has also agreed with the department argument, saying that though the reference of the section is maybe wrong, but the source of our is still there with the another section, that is section 5 subsection 4, which is amended with effect from 1st February 2019. The amended provision is sufficiently gives the power to make not only the actual recipient, any other person as a person liable for tax. they can deem it as a recipient of the supply and they can tax it. So the Supreme Court has agreed with this argument and told that source of power is still there as long as source of power is there in the enactment. Just because the reference or the wrong reference was made, that cannot invalidate the levy itself. So they have upheld, they have accepted this argument, referring the settled decision in this regard. Yeah, come down.
So basically the argument of the Revenues Council, which was that Section 5.3, although may not be applicable, assuming but not admitting, but Section 5.4 is certainly empowering. Sir, you may be remembering Section 5.4 was introduced to curb those cases wherein RCM was made applicable from unregistered supplier to a registered person. How beautifully this was put before the Honorable Court, and this argument was very well accepted, and this was the major tool of the Revenues Council. But at the same time, one beautiful tool was available with the SEC's council as well, and that was the concept of composite supply, which was introduced under the GST regime, and the bundling from the service tax regime, the concept of bundling of services and all those things, which took away all those thought process of aspect theory, of segregating the transaction and all those things. And what the SEC's council argued that the transaction is one and the single transaction wherein the foreign supplier is supplying certain goods, he is levying freight, and the freight, even in the composite supply definition, there is an example given. The freight is the integral part of the entire transaction, and whereas the principal supply, the predominant supply is the import of goods, and thus the entire transaction is a composite supply, and one single tax would be applicable on the entire transaction. There cannot be two treatment for the transaction in question. So this was the game changer argument in this case. Over to Venkat sir, how Supreme Court took perception of this particular argument.
Yeah. In fact, this is the actually, except this, if this argument was not there or this submission was not there, I think the entire case would have gone in favor of the department. This is the argument which has actually saved the taxpayer and has given this conclusion in favor of taxpayers. Because as I explained in my earlier discussion, Gujarat High Court decision was done in two parts. One part is that Indian importer is not a recipient in the CIF transaction, thereby he cannot be liable for GST and reverse charge. Second argument was that second part of the decision was, if at all liable also, because it is at the time of import the GST was already paid on the import transaction, including the transportation charges. Thereby they cannot be again the tax on the same person on the same transaction by just revisiting the one component of the same transaction. So that is another reason given by the Gujarat High Court. In this case, Supreme Court has reversed the first part of the Gujarat High Court decision, saying that Indian importer will become recipient, as we have explained so far. And this second part of the Gujarat High Court decision was actually given in favor of the taxpayer, which was also Supreme Court has agreed with this Gujarat High Court and held that when the same importer has paid GST on the import transaction, including transportation, it will become a composite supply. And once by virtue of composite supply theory under Section 7(8) of CGST Act, which is made applicable to IGST, which provisions again are borrowed and referred to the customs by levy of IGST. So once same IGST has been paid on the custom import transaction, including on the transportation, they cannot be again GST and reverse charge on the same person on the same transaction. And they have given a small example saying that today you are bifurcating transportation and you are saying that it is liable and it is different transaction. And tomorrow again you come and bifurcate insurance is separate transaction, they levy again GST and reverse charge insurance, because again the insurer may be from outside India. Similarly, like various components of the final output transaction will have a lot of components. So you cannot keep on revisiting and breaking it, and for your sake of argument saying that this is separate transaction, that is separate transaction. And in fact, the Supreme Court decision also has given a very beautiful finding saying that your arguments are self-contradictory. In first part of the argument, you are saying that recipient, though he is not a contractual party, he will become a recipient by virtue of various indemnification. If that is the case, how come you say that now that, this transaction is different, that import transaction is different and service transportation transaction is different. This will become a self-contradictory arguments which cannot be allowed. So finally, Supreme Court told that because the same importer is paying GST under reverse under the import transaction, including transportation, they cannot be again reverse charge on the same person on the same subset of the transaction. And accordingly, on this one line of the argument and one line of the one part of the decision, it was gone in favor of the taxpayer. Otherwise, this argument or this provisions were not there, it would have completely gone in favor of the department. So this is very crux and thrust of the conclusion to which has made the case gone in favor of the taxpayer, and which has given a very big relief to the persons who are burdened with the lot of GST being paid, which is becoming cost in many cases. Yes,
So,
Bhavesh.
in a nutshell, if we see out of the majority arguments put forth by revenue, all were accepted. There was only a single concept of composite supply which was savior for the industry and the taxpayer. So one argument was enough to counter all the arguments, and finally the matter was decided in favor of the SSC. Venkit sir, beside this, there were some more beautiful points like council, roles and responsibilities of the GST council. It was very clearly clarified. As far as delegated legislation are concerned, the decisions or recommendation of the council, which is a recommendatory body, would be binding. But as far as the prime legislation are concerned, where there is no specific reference, the council's recommendation would be only recommendatory. And to this, some interpretations are coming such that if the council recommends any matter other than GST or decides other than GST, then that would be recommendatory. But all other GST related thing would be mandatory because it is a federal body maintained for federal structure. So this view is coming. But the judgment clearly mentions that those recommendations which do not have any specific mention or on the parent act, recommendation related to parent act will not be having any binding effect, and only rule making power or delegated recommendations about delegated legislation will have binding effect. So to this your view, then we can guide on the way forward to the next phase.
Yeah, this is of course is on the constitutional framework of GST Council. In the basis, what the Supreme Court has said is that GST recommendations are not binding on the union government or state government. So it has only as a persuasive value, and union and states has a independence, their own independence to choose whether to follow the recommendation, not to follow the recommendation. And this was given in the reason that if you look at the judgment also in some para, they have given a clear-cut finding saying that if you look at the difference between these provisions of GST and Constitution Article 279A, the recommendations of given for the parent enactment, that is CGST Act or IGST Act or State GST Act, this is need not be tabled in the Parliament. So whereas in case of rule making power, they clearly told that whatever the recommendations of the government has to be tabled in the Parliament. So this is the background in which they have told that. Whereas in the case of prime legislature, that is CGST Act or IGST Act, for the states it is SGST Act, the recommendations of the council are not binding, while the rules, that is either rule to procedures or the exemptions or the rates which comes in the delegated legislature, the recommendations are binding on the GST council. Recommendations binds the both union and state. This is the line of difference what they have given by the Supreme Court in this decision. Of course, it is creating, it is raising a lot of questions on the entire origin of the recommendations of the council, because it may lead to different implementation by different states. But we have to see how government is going to react to this decision. And of course, this is going to create wherever there is some kind of disturbances or difference of opinion between the states and center, we have to see how this will be practically going to impact their decision. Suppose there is some tomorrow union government wants to make some amendment in the CGST Act. So they may, they may propose, but some state may oppose it. So how this going to be implemented uniformly across India is going to be a big question. So we have to wait and see how, it is going to practically impact, and how is going to be clarified, further clarified by the Supreme Court in coming future. So keeping that, I know this issues, constitutional issue and the legislative issue aside, otherwise the decision of the final conclusion, final result of the decision is a good relief or big relief to the importers, because they have been in struggle, in trouble, and also in state of confusion from last 5 years from the inception of the GST, because this 5% GST on the transportation is becoming a big cost to the many players, particularly persons who are into exempted business like healthcare and all. Is becoming a big cost. So this is given this judgment has given a big relief, and so they finally get, I think some kind of relief, at least for the initial years. We have to wait and see how government is going to react to this judgment, whether they are going to make a retrospective amendment to nullify or overcome, or they are going to accept it, or they are going to make it a prospect amendment, and all that we are going to see. We have to wait and see. Yes, Bhavish.
One more important point, Venkat sir, was that in the Gujarat High Court decision, they rendered that the importer not being the recipient would not be entitled for the input tax credit. But one critical point in this judgment is here the levy, RCM levy, has been quashed without rendering the importer, without discarding the importer to be a recipient. Means the importer is a recipient, and now henceforth he is eligible for ITC for the past cases. So in a situation, we'll take one by one situation, and Venkat sir will answer. If the tax was paid and credit was taken and available and utilized also, then what is Venkat sir views in this regard?
Yeah. Anyway, now that whatever tax was paid, it was utilized. So there is no benefit of you, going anywhere. So nothing has costed you. So you can, continue the, can leave it as is, because you have taken it, you have paid it, and taken it as an input credit, and utilized it also.
Yes.
Yes.
So there is no need for reversing it or applying for refund. You may maintain status quo for past transaction. Future, you may stop paying RCM on ocean freight. So
yes.
Next case is where the credit was not available but taxes was paid. So can you apply for refund, and the time limit would be?
Yes, can be applied for refund. So this maybe that time 2 years time limit, whatever the refund within the 2 years time limit is going to come by virtue of the decision, unless government comes with some different treatment. As far as beyond 2 years, of course, it is matter of dispute again. The department, trying to argue from service tax and VAT regime, saying that, beyond 2 years or earlier, whatever the time limit, there it is staying time barred. So in all those cases, wherever the refund is there beyond 2 years, it is better, it's suggestible to go directly to High Court and file a writ petition and ask for the refund. And whatever within the 2 years, they can file it with the division office and they can get the refund.
Yes. So last case where the ITC was availed and left unutilized, in that case, refund is suggestible, because anyway you are not using the ITC, so you may better reverse. Interest is anyway not there, and you may apply for refund in the similar scenario like 2. So
yes,
with this short video, we intended to clarify various arguments put forth by the revenue and the SSC, and the how finally Supreme Court interpreted the decision. This is a most welcome decision, and I hope the industry, we hope the industry and the taxpayers will be getting benefited out of it. Further, the department will also have substantial clarity about the powers of taxating statutes and all those things. So with this, I would like to thank Venkat sir, and thank you everyone for seeing this video. Thank you so much.
Yeah, thank you, Bhavesh, for organizing this video, and thank you for all viewers for sparing time and viewing this. Thank you.